My name is Harry, and I'm from London.
Meghan Markle here.
Federal Rule of Civil Procedure 15 says that court should freely give leaves to amend when justice so required. Okay, despite the general premises of approach, a district court need not allow amendment where 1. There has been undue delay, bad faith, dilatory motive, or repeated failure to cure deficiencies by amendments previously allowed. Allowing amendment will cause undue prejudice to the opposing party. I understand. So it seems like the half-sister was trying to change things based on what was previously filed, I think. And then since it was against her, in my humble opinion, if my memory served me well, and then she went and do some amendment. And I remember reading some tweets, some screenshots some squaddies were putting, and showing that she's saying, oh, it's not over yet. I'm paraphrasing now. It's not over yet. The fat lady haven't sung yet. She's going to go after it. Something like that. I'm paraphrasing completely because I don't follow her. And I was reading the screenshot. It must have been in one of my videos. And I think this is what the court is making reference to. Okay, so if you keep on changing things, so the judge cannot really take it into consideration when the original has already been filed. And the court is saying, what about the other party? How is this being fair to the other party? Remember, the judge is supposed to be neutral. So don't keep on changing things. And then, you know, if she keeps on giving you chances and chances, how is that fair to the other party? And this is why I said the last time I went over the documents, and I remember saying, I think the judge is giving her another chance, the half-sister, another chance to prove herself with her claim. Because from what I saw, there was something dismissed with prejudice, dismissed without prejudice, or something like that. I look it up, and this is one of those I had issues with. And one of the squaddies, one of the my subscribers who probably into all of this, who know more about this than me, explain in the comment section. And then so anyway, let's move on. I don't want to go into detail and tie myself into a pretzel. So let's continue. So I understand what the judge is saying here. The half-sister cannot keep on changing. What about Meghan? Okay, she has to be neutral of that. So let's continue, meaning the judge has to be neutral. Okay, allow amendment will cause undue prejudice to the opposing party, or amendment will be futile. Brian versus Dupree, there's all of that. And where a communication could not possibly serve as ground for a claim, the court is justified in dismissing it with prejudice. What is prejudice again? That's the part I keep. Did I dismiss with prejudice? I have it open. Okay. The plaintiff cannot refile the same claim. Okay. So she cannot bring that back up again. Yeah. Okay. I knew I would be needing it. Okay. Where was that? Dismiss with prejudice. There's all of this. Holding that dismissal with prejudice is appropriate where amending will be futile because viable defamation action does not exist based on the statement plaintiff attributed to defendant. Okay, so she's dismissing it because there's other thing that has already been proven that it was not defamation. So she dismissed it completely. Don't bring it back up again. Plaintiff claims, that's Samantha, claim based on the CBS interview have fared no better on second review, although she now properly quotes the statement rather than paraphrasing or changing them. There's that here. Each statement is incapable of supporting a defamation claim. Okay, so now she quote her. I knew the quote. I think I remember this part when I was reading it there last time. That was one of the parts she said, was it dismissed without prejudice or something. Therefore, with the benefit of substantial briefing and 2 rounds of oral argument, the court concludes that plaintiff will not be able to cure the deficiencies in these claims through amendment. She has amended her complaint multiple times and yet still Let me pause so I could cough. Oh my God, I had to drink after that. Okay, she had amended her complaint multiple times and yet still fails to sufficiently plead multiple elements. Moreover, the court has found that the statements on which the claim are based are not actionable. As such, further amendments will be futile. These claims are without merit, and they will be dismissed with prejudice. Okay, so there's all of that. So don't bring them back up again. So now we go back to Netflix. We go to Netflix. The Netflix claims differ from those based on the interview and that they are plucked several hours long episode of Harry and Meghan, for which transcripts were submitted. Okay, so there's all of that. For episode 5, video footage and a transcript were submitted, as the episode contained certain images and graphics not amenable to transcription. The court has reviewed the transcript and footage. Defendant separates the Netflix statement in 2 groups, those said by defendant and those said by Christopher Buzzi, a non-party interviewed in the series. There's that. The court will do the same, beginning with defendant 5 statement. Okay, so let's see here. Statement 5 and 7, Netflix series. The court addresses the first 2 statements from the series numbered 5 to 7 in motion. Together, statement 5 documents reads the follows. I was with my mom during the week and with my dad on the weekend, and my dad lived alone. He had 2 adult children who had moved out of his house. Okay. Next statement, 7, there's that. I don't remember seeing her when I was a kid at my dad's house, if when they will come over. We seen her going fishing with her father, and you didn't see the adult children. Okay. So there's that here. Here again, I don't remember. That alone should tell you this is her opinion. Okay, and here, what did she say here? I was with my mom during the week and my dad on weekends, and my dad lived alone. He had 2 adult children who had moved out of his house. Okay, so with that in mind, let's continue. Plaintiff alleged that, in fact, defendant lived mostly with her father and visit her mother some weekends. Plaintiff alleged that, in fact, Meghan, defendant is Meghan, live mostly with her father and visit her mother some weekends. So she switched it completely around. She also disagrees with how the family's living arrangement were described, stating that when defendant was in junior high school, plaintiff, that's Samantha, lived on the property and was always home when defendant came home from school. Plaintiff states that she often drove defendant to school herself or with her father and helped her in other ways. Defendant's statements were allegedly false because, in reality, defendant Meghan was close to plaintiff, which she lived in her father's home, and there is no way that she could have forgotten it. You cannot force somebody to remember what you remember, considering that she continues to have memories of other issues at that time. Defendant moves, okay, that's Meghan here. Defendant moves for dismissal on the ground that both statement or opinion regarding her own childhood. Okay. Further, she argues that plaintiff fails 2, and logically cannot allege actual malice as to either statement, which will require a plausible allegation that defendant doubted her own recollection and thereby recklessly disregarded the truth. Defendant argues that the allegation that there is no way, meaning the defendant, Megan, could have forgotten, seeing plaintiff is not a workaround. Is not a workaround. Defendant also argues that the supposed implication of the two statements, the denial, the plaintiff, play a part in defendant's life and her upbringing, there's that here, and yet again, a non-actionable opinion about her childhood and family life. Plaintiff responds that both statements are false statements of fact, that their father, Thomas Marco, defendant and plaintiff did not live alone, and that defendant falsely claimed to not remember plaintiff documents 79 at 8. She argues that the issues in the statement are provable by common sense. What? Provable by common sense? How the hell is that supposed to mean? When you're looking at things that is going on in the UK, most people will say this is common sense thing, but apparently some people lack of common sense. But how is it? But anyway, I'm jumping off. She argues that the issues in the statement are provable by common sense and unspecified other indicia, such as payment, photograph, or testimony. Defendants replies that neither statement could be construed as defamatory even if they were verifiable. Okay, documents 82, 4. Finally, in her sole reply, plaintiff contend that the issue of whether Megan had no memory is that which is more subject and which can be proved by common sense and a jury's experience. Oh my lord. The claim based on the statement 5 and 7 are fatally deficient. Let me pause again so I could laugh. Oh my god. Let me read that again. Fatally, the judge was throwing some shade. The claims based on statements 5 and 7 are fatally deficient and due to be dismissed with prejudice. Don't bring this shit back up again. Okay. First, statement 5 is not plausible, capable of being considered defamatory. A defamatory statement tends to harm the reputation of another by lowering him or her in the estimation of the community, or more broadly stated, one that exposes a plaintiff to hatred, ridicule, or contempt, or injure his business or reputation or occupation. In statement 5, defendant state that she lives with one parent, her mother, during the week and another, her father, on weekends, and that at some point during her childhood, her father's 2 adult children moved out of the house. Okay? Defendant's memory of childhood miniature does not plausibly defame plaintiff. First, statement 5 barely mentioned plaintiff. They didn't even mention her. So to say only that at some point during defendant's childhood, plaintiff moved out of her father's house, it is not plausible that plaintiff would be exposed to hatred, ridicule, or contempt as a result of this statement, nor will it be plausible endure her business. At worst, it is a minor and material inaccuracy. There's all of that. Dismissing a defamation claim with prejudice for not plausibly defaming the plaintiff. Okay? Unlike the statement in Mercola, defendant did not implicitly or overtly reference plaintiff's profession, diligent character, or anything beyond her having moved out from her father's house at some unspecified date and time during the defendant's childhood. Therefore, considering the statement in context of the serious and drawing all reasonable inferences in plaintiff's favor, the statement simply cannot be defamatory because it will not tend to harm plaintiff or expose her to hatred. Okay, so that's that. I'm not gonna read all of that. I guess these are the cases she made reference to. Ridicule or contempt. There's that here. Where the court find that a communication could not possibly have a defamatory or harmful effect, the court is justified in either dismissing the complaint for failure to state a cause of action or in granting a directed verdict at the proof stage. Additionally, Statement 5, as it relates to how defendant split her time as a child, is substantially true based on plaintiff's own allegation. Again, they're using her own word again. Falsity only exists if a publication is substantially and materially false, not just technically false. See Merritt, there's another case here. Here, even if plaintiff somehow could prove that defendant spent more time as a child with her father than she remembered, the gist of defendant's statement will still be substantially and materially true. There's that here. Per plaintiff's own allegation. Even they're using her own word. Per plaintiff's own allegation, defendant spent some time, there it is, some time with her father and some time with her mother. There's that here. This statement therefore cannot support a claim for defamation because it is substantially true. Let me release whatever's going in my brain right now. I'm gonna need to make more coffee. Okay, this statement therefore cannot support a claim for defamation because it is substantially true. Okay, plaintiff goes on to list extraneous facts that have little to do with the statement. Claiming to have helped defendant with her homework and taking her shopping at 11. Her response conceded that it is difficult to prove what one's memory may be, but argues that issues of memory are provable by various indicia, including previous payments, photographs, or testimony to uncover the truth of a situation. There's a docket here. In fact, though, it will be impossible for a plaintiff to objectively falsify defendant's statement, given that it was a memory provided in the context of how defendant felt about her own childhood. That's a very good point. You cannot go in Megan's brain to see what she remembered. She was going based on memory. Therefore, Florida law and the First Amendment wisely bars the claim from going forward. Wow. Very interesting. The court doubts that Statement 7 could possibly be considered defamatory either. Nevertheless, it is subject to dismissal based on a more obvious defect. It is a protected opinion, in addition to plaintiff's failure to allege actual malice. Okay, first Statement 7 is a protected opinion because it is not subject to empirical proof or objectively verifiable. Let me not go there. Defendant states that she does not remember seeing the plaintiff, the half-sister, when I was a kid at my dad's house, if and when they will come around. In the clips preceding this statement, she and Prince Harry describe their personal goals and wishes for themselves as parents and for their children. A reasonable viewer could not perceive it as defame plaintiff, considering the statement in the context of how defendant remembers being a child of divorced parents and hopes to be as a parent. More the way they the way they show the thing on Netflix, the court even recognize that. Let me read it again. A reasonable viewer could not perceive it as defaming plaintiff, considering the statement in the context of how defendant remembers being a child of divorced parents and hopes to be as a parent. Moreover, considering that defendant qualifies the statement by stating she does not remember seeing. There's the part here. Remember. That's by memory. Seeing plaintiff if and when she and her brother came around. The falsity of this statement could not objectively be proven. Okay? She may not remember when they come around. Maybe when she's over there, they're not over there. Okay? Finally, plaintiff fails to plausibly allege actual malice as to either statement. To do so, she must include factual allegations that allow the court to possibly infer defendant made her statement. with knowledge that they were false or with reckless disregard of whether they were false or not. There's that. Internal citation and quotation omitted. Okay. As previously mentioned, plaintiff primary actual malice allegation is a conclusory recitation of the standard referencing her defamation by implication claim in particular. There's that here. She also stated that at the time the statements were made, defendant Megan had actual knowledge that these statements were false. In addition, plaintiff argued that defendant knew that the fact within the statement were false. How do you know what she knew if she didn't tell you she knew? Okay, and that her statement was stated with actual malice. Okay, these allegations or legal conclusion that the court need not take as true even at this stage. Sufficiently pleading actual malice requires plaintiff to allege facts that will allow the court to reasonably infer that the defendant actually entertained serious doubt as to the veracity of the published account or was highly aware that the account was probably false. Okay, the conclusory recitation mentioned above failed to meet this standard. Plaintiff claim based on statement 5 and 7 will be dismissed with prejudice because amendment will futile. Okay, so there's that here, so she cannot bring it back again. Okay, let's see here. Specifically, having reviewed the context of the series, the complaints of the parties, briefing and oral argument, this communication could not possibly serve as ground for a claim. There is no way for plaintiff to objectively prove either statement, which makes them protected statement of opinion. Okay. Additionally, statement 5 substantially true from plaintiff own allegation. Oh my God, they're using her own thing again, and she fails to possibly allege actual malice as to either statement. Therefore, this statement cannot support a claim for defamation. Will be dismissed with prejudice. There's that here. Finally, plaintiff conceded at all argument and in her reply, there's that statement 6 is non-actionable based on the numerous public report that plaintiff has claimed that she raised defendant. The law supports this conclusion because this claim was repeated in numerous prior reports, including one quote in the series itself. A finding of actual malice is prejudice. Let's see this here. These articles were cited in defendant's request for judicial notice. Wow. So there's some articles here. Megan's, let me pause for a second and see what these are about instead of me putting it here. I saw it, but it's a little bit too technical for me. I'll put the link of this. You guys could look at it yourself. I don't want to go into that. Okay, so let's continue. Okay, these articles were cited in defendant's request for judicial notice. There's that here, which plaintiff withdrew partial opposition to at oral argument. Therefore, the claim as to statement 6 will be dismissed as well with prejudice. So Megan showed a proof of something here, and then once Megan did that, she withdrew it. I mean, they're taking people for stupid. Oh my God, statement 16 and 17, Netflix series, Dark 75 at 26. The next two statements were presented in the following context. First, a social media post, a tweet from an unknown user with a blur out screen name was shown. Okay, this is new to me. Let's see here. Condolence of Prince Harry and Meghan Markle. Enjoy your moment. We will not support you, and the day your wedding curse you. Okay, Megan, there's the word here. Witch, gold digger, amour, sex maniac, dirty. Oh my God, there's all of that. Okay, gold digger, we hate you. There's all of that. Then, defendant and Prince Harry said the following. Okay, so where was that? Was that in the Netflix? Yes, that was in the Netflix. So they took something from tweet and they blurred the name out, and this is what was there. Then defendant Meghan and Prince Harry said the following. Prince Harry, the seriousness of what has happened to here, there's that, and what happened to us and what continued to happen to her, that needs to be acknowledged. defendant, which is Megan. Also, I think for people to really understand, when you plant a seed that is so hateful, what it can grow into. I mean, just a couple of days ago, I was going through the manual for our security team at home, and on one of the pages that I happened to flip to, it was about online monitoring. And they were like, quote, if you see a tweet like this, please report it to head security immediately. And it just said, Megan just need to, there's the word here, God forbid, God, you have them. That's not what it says. I put that. This is what it actually said. Quote, Megan needs to, someone needs to, there's the word here. Oh my God, they're too much for me to even say it. I'm gonna bleep them out. Let's start all over again. And it just said, Megan just needs to ink. Someone needs to ink her. Maybe it should be me. Defendant, which is Megan. And you just like, okay, that's like what actually out in the world because of people creating hate. And I'm a mom. That's my real life, And that's the piece when you see it and you are making people want to kill me. Okay, it's not.
You are making people want to kill me. It's not just a tabloid. It's not just some story. You are making me scared. Right?
Okay, I remember this. I even have that clip. Plaintiff argues that the underlying comments were defamatory. Specifically, she exerts defendant's statement that, quote, when you plant a seed that is so painful, what it can grow into, and you're making people want to kill me, you are making me scared. Okay, defendant contend that the statement based on the context and proceedings information refer not to plaintiff but to the media and a group of unspecified secondary hate accounts. There's all of that. She argues that the plaintiff cannot magically wave away the context of the statement when the transcript contradicts her allegation. Finally, defendants argue that the statement cannot support a defamation claim because neither sufficiently specify plaintiff as its subject. As to statement 16 through 18, plaintiff essentially responds that the statement are defamatory when all of defendant's statements are combined and that these statements, when added to the mosaic, are indivisibly setting the framework which support the defamation. No authority is citing for this line argument. To the contrary, the court agrees that these statements are clearly and fatally deficient. Plaintiff is indeed not named in neither one. And based on the context, the transcript and the footage of the episodes, there are not sufficient fact references to identify plaintiff as the subject of the statement mosaic. There's all of that. As to statement 17, the court agrees with defendant that a reasonable viewer will identify the you and the phrase you're making people want to kill me, you are making me scared, as either the unnamed social media user whose message was shown on the screen or the media based on defendant's reference to a tabloid in the same statement. This being the case, the court cannot plausibly infer that statement 17 is of and concern plaintiff or possible states a defamatory claim against defendant. So yeah, that's that. Whew. Statement 16 is even more clearly deficient as it fails to reference any person at all and instead is defendant's opinion on how hate can grow onto something more. After a tweet reference above was shown, defendant states, quote, also, I think of people to really understand, when you plant a seed that is so hateful, what it can grow into. Especially what we saw last week was, my goodness. Okay, in context, a reasonable viewer might take this to reference the previous discussion of the tabloid, the unnamed account allegedly attacking defendant online or other groups. This, however, is not enough for the court to reasonably infer that the statement contains sufficient facts or references to identify plaintiff as its subject and thus be capable of supporting a defamatory claim. She didn't put the name in there. Moreover, both statements are protected opinion because they are not objectively verifiable or statement of fact. Defendant's statement that she believed the hate posts were making people want to kill me. It's not just a tabloid. It's not just some story. You are making me scared, right? It's not subject to empirical proof. Turner 198. It is no more possible to falsify defendant's statement that people should be aware of how a seed that is hateful can grow. Therefore, neither statement can support a claim for defamation. Based on these fundamental deficiencies, the court finds that plaintiff cannot state a plausible claim based on either statement even through amendment. Therefore, the claim based on statement 16 and 17 will be dismissed with prejudice. Okay, so there's that. So there's the Boozy part here. Boozy's statement. In addition to defendant's statement from the Netflix series, plaintiffs seek to hold defendant liable for a number of statements by Christopher Boozy, a social media analyst who worked for Bat Sentinel and was retained by defendant for the series and is employed by defendant. As I'm reading this, what I'm thinking here, these things that they're bringing in just because they're upset at what was being uncovered, so they try to bring this suit into play and all of that. It's crazy. But anyway, in addition to defendant's statement from the Netflix series, plaintiffs seek to hold defendant liable for a number of statements by Christopher Boozy, a social media analyst who worked for Bat Sentinel and was retained by defendant for the series and is employed by defendant. And the course of and scope of his retention, said the defendant published 9 allegedly defamatory statements. There's that. Defendant argues that she cannot be held liable for this statement because they are not her statement. And 2, even if they were, they are non-actionable opinion or substantially true. Plaintiffs disagree, arguing that defendant published the statement regardless of whether she was their actual author. There's that. Further, plaintiff argues that the statements were defamatory. Publication. Okay, publication is an element of defamation. Okay, there's that. As the Florida Supreme Court has explained, because the publication of a statement is a necessary element in a defamation action, only one who publishes can be subject to this form of tort liability. Okay, there's this case here discussing the definition of publisher and a negligent action involving distributor liability, which is indistinguishable from a garden variety defamation action. There's that here. These are cases. I'm not all of them I will go into. I skip a lot of them. Taking her allegation as true and drawing all reasonable inferences in her favor, plaintiff sufficiently pleads that defendant published the statement. Her allegation that Boozy was retained by defendants for the series and made the statement while the defendants employ and in the course and scope of his retention, and enough to withstand defendant's challenge, at least at the motion to dismiss stage, holding that, in addition, both the negligent communication of a defamatory statement and the failure to remove such a statement when first communicated by another party, each alleged by plaintiff, here under a negligence label, constitute publication. Okay, defendant argues that these 6 statements of Boozy's are not actionable because they are not directed to plaintiff and therefore are not plausible defamatory. Okay, plaintiffs concede that it is possible that statement 8 and 15 were not directed at plaintiff but disagree at the rest. The court agrees that these statements are due to be dismissed with prejudice because they cannot plausibly support a defamatory claim. Yeah, so whatever Boozy had said, it was just I believe I need to look at it again. I don't remember everything that he said, but based on these, the court said it was, oh, there it is down here. Never mind. Let's read this. Boozy. So this is not your everyday trolling. It's insane, and it was done by people. There it is here. Not specifically her, just general. By people who were just not the typical, quote, unquote trolls, sick or housewives. These are middle-aged Caucasian women creating just constant attack from Go Back to America to basically, why don't you die? All right, so it's even him. He didn't even say who it is. He just said people. Okay, defendants argued that the plaintiff clearly was not among the housewives' boozy references based on the immediately preceding footage of various YouTube personalities, none of whom are plaintiff, attacking defendant. Documents 74 at 15. Plaintiff responds that it is possible this statement was not direct at her, though they are intertwined. Oh my God. They are intertwined in the statement made against plaintiff. Documents 79 at 11. Plaintiff argues that the descriptor middle-aged Caucasian woman applies to her. I'm laughing because she's just pinpoint different things. And then I guess because she's white too. So therefore it's referring to her directly. Oh my God. But let's continue. Okay, plaintiff argues that the descriptor middle-aged Caucasian woman applies to her and that her claim should thus go forward. Defendant replies that this description applies to millions of women. Exactly. And that the phrases used in this statement will be pure opinion and non-actionable even if plaintiff have been identified. Defendant provides an accurate description of the statement's context, and the court agrees that this claim is due to be dismissed. First, there are insufficient facts or references to identify plaintiff as the subject of the statement. Marked in this, that's another case. Thus, it cannot be defamatory toward her. Next, there is indeed no way to objectively prove or disprove that a group of individuals are trolls. This characterization is unverifiable and not subject to empirical proof because it is not capable of being proved false. The statement is protected from a defamatory action. New York Post versus, there's another case here. Additionally, as is true regarding all Bouzier's statement discussed infra, plaintiff failed to allege actual malice because there is no way to plead a defamation claim based on the statement of protected opinion, which does not sufficiently reference plaintiff in the first place. The plaintiff also failed to plead actual malice. The court will dismiss this claim with prejudice. Don't bring it back again. So let's see here. Prince Harry. Perhaps the most troubling part of this is the number of British journalists interacting with and amplifying the hate and the lies. When a lie spread on social media is dangerous, of course it is, but when that same lie is given credibility by journalists or publishers, it's unethical and, as far as I'm concerned, an abuse of power. My goodness. Okay, I'm almost there. This statement was included in the operative complaint is perplexing and suggests haste and misunderstanding of the law or lack of diligence on the part of plaintiff counsel. What? They're blaming the lawyer on that. Based on the transcript and the footage of this episode, Prince Harry made this statement, not Bouzie. Oh shit. What? And not defendant. What in the name? Moreover, it is unclear how this statement could be defamatory toward plaintiff as it does not reference her. Defendant point this out. What? Plaintiff responds as follows. Let's see here. Statement number 11. It's not defamatory in its own right. It is simply implying that Samantha's bullhorn is greater than it will seem, and that British journalists are amplifying the hate which they are falsely accusing Samantha of spewing. As to malice, Meghan acted with malice when she chose the words and made the statements about her sister, the plaintiff. What the hell? Wow. Okay, thus plaintiff completely ignored the fact that the defendant did not make the statement. My goodness, she could actually, if Meghan want this, let me just continue. I'm already close to 2 hours. Okay, this is going to be two-part, by the way. Thus, plaintiff completely ignored the fact that defendant did not make this statement. First, in her complaint, she alleged that Bouzie made the statement. Then her response discusses defendant's malice and choosing the word and making the statement. DAC 79 at 13. In fact, this statement was spoken by somebody else entirely. The court agrees with plaintiff on concession that the statement is not defamatory in its own right and will dismiss this claim because plaintiff failed to plausibly allege that the statement identified her in the first place. Okay. Nor does the complaint or any pleading explain how defendant can be sued for Prince statement. Amendment will be futile and this morally deficient claim is dismissed with prejudice. Okay, I don't know why I paused for a second here, but it wasn't recording. Let's see. These three statements made by Boozy came back to back in the same interview response. Boozy statement 12. For the main hate account, their primary motive is monetizing this stuff. Statement 13, but the secondary account is about hatred. Statement 14 is about race. Defendant is Megan, argues that the claim must be dismissed because plaintiff is not identified as one of the main or secondary hate account. Moreover, she argues that the claims are per se non-actionable because where a group is composed of 25 or more members, Florida law holds that plaintiffs cannot show that the statements were of and concerning them. There's that, another case. Okay, so there's that. Plaintiff responds that defendant can be held responsible for Boozy's statement, but fails to initially respond to the argument that the statement are not of and concern plaintiff and are non-actionable due to the group size. Okay, that 79 at 12. Elsewhere, under the headline allegation that Samantha was a racist, plaintiff argues that when defendant spoke negatively of people who she grouped as the ones who all had the same qualifying factors to belong to the group, she was not speaking of an actual group. Finally, in her reply, plaintiff argues that defendant's group defamation argument, okay, let's see here, would be a good point except for the fact that there was no such group. And Thomas, for instance, the group was allegedly defamed and the plaintiff sought inference that it therefore defamed the plaintiff. This is not what is occurring here. Here, there is no group. It was only Megan and Boozy. Categorizing people into a group of people who spread disinformation is spewing disinformation makes you a member of a group by including Samantha in the group. Megan and Boozy were specifically saying that Samantha spread disinformation. Okay, plaintiff response is difficult to parse and contradicted by the transcript. Boozy said the following in the relevant statement. We look at 114,000 tweets. We were able to then determine that 70% of the, hateful content came from just 83 accounts and they had a reach of 17 million people. Plaintiff argued, okay, that's Samantha. Plaintiff argues that there is no group because, how do you know? But you're not the one who did the thing. I mean, let's continue. It was only defendant and Boozy categorizing people into a group of people who spread disinformation. That's 89 at 5. Her circular argument is essentially that no group exists because she is at odds with the individuals who identify the group. Defendant and Boozy, plaintiff cites no authority and her argument fundamentally does not add up. Therefore, the court agrees that this statement is protected because when a group is large that is composed of 25 or more members, court consistently hold that plaintiff cannot show the statement were of concerning them. Thomas 699. So, that's another case here. 12. Statement 12 through 14, which refer to a group of 83 accounts and do not specifically reference plaintiff, are non-actionable under Florida law and will be dismissed with prejudice. Okay, there's that here. Let's continue. Statement, there's Boozy. And the focus was predominantly on Megan, comparing her For example, a monkey, and then also there will be a derogatory terms where they will use the N-word on tweets. Okay, defendant argues that Boozy did not accuse plaintiff of using the N-word in this statement, and that because this statement follows a reference to 83 accounts spreading disinformation, it too is precluded from supporting defamation claim as a matter of law. Plaintiff responds that she presumably referring to defendant, although Boozy in fact made this statement that plaintiff never used the N-word on any tweet, and that this was false. In essence, again, plaintiff failed to address the substance of the argument beside in her reply. Whereas previously discussed, she unpersuasively argues that no group exists because she does not agree with the individual who created the group. Plaintiff's claim as to this statement is due to be dismissed because it is not possibly of and concerning her, is thus not capable of being defamatory, and because it lacks sufficient facts or references to identify her as the subject of the statement. Okay, as this statement cannot support an actionable claim against defendant, plaintiff claim will be dismissed with prejudice. There's that here. There's another quote here. Boozy, Samantha Marco was part of a group that was putting out a lot of disinformation. Samantha had her account suspended, and then we actually sent Twitter a list because she had like 11 additional accounts. What the hell? Boozy, and there's Boozy talking here. Statement 10, Boozy, and we were baffled by this. How can the half-sister of Megan be part of the hate group? Okay, defendant argues that these two statements, the only ones to specifically identify plaintiff, are both unfalsifiable and thus protected from a defamatory action. Specifically, she cited an opinion from the Middle District of Alabama, which granted Rule 12b-6 motion, holding that the meaning of the term hate group is so debatable, loose varying, that labeling a plaintiff, which is Samantha, as one is unsusceptible proof of truth or falsely. There's another case here, analogizing hate group to non-actionable terms, fascism, radical right, and political Marxist. There's that here. Defendant argues that the same is true of the concept of disinformation, citing, there's all of that. Plaintiff responds that she is not arguing that the defendant is liable for defamation based on the disinformation or hate group allegation. There's that here. Instead, she argues that this is a statement which ties all the allegation of racism, spreading hateful information, which is making people want to kill her sister Megan, and the big lie that Samantha is an evil opportunist. This is more than an allegation. It is the string which is tying the package together. Plaintiff failed to respond to defendant's argument regarding the statement being protected opinion, which are well taken, and the court agrees that neither statement can be empirically verified or falsified, and thus both are non-actionable. So because she didn't respond back, the judge, let me pause. Okay, I need to finish. This is more than an allegation. It is a string which is tying the package together. Plaintiff fails to respond to the defendant's argument regarding the statement being protected opinion, which are well taken, and the court agrees that neither statement can be empirically verified or falsified, and thus both are non-actionable. There's this case here. Because the statement cannot support a claim as against defendant, they will be dismissed with prejudice. There's all of that. Plaintiff various argument regarding the implication of the statement and that they tie the package together will be addressed as to count 2. Okay, so there's that here. There's Boozy here. Samantha Marco was part of the group that was putting out a lot of this disinformation. Samantha had her account suspended, and then we actually sent Twitter a list because she had like 11 additional accounts. Okay, defendant argues that this statement was substantially true by plaintiff's own admission and that she again fails to plead actual malice. Doc 74 at 18. Defendant further claimed that the failure to plead actual malice is apparent because the series affirmatively included plaintiff prefer explanation for the dozen Twitter account and suspension. In response, plaintiff state defendant used a series of statements to create the implication that plaintiff was suspended from Twitter. Okay. Plaintiff complaint contradicts the argument that this statement was a false implication by admitting that the suspension occurred. They use her own thing. They use her own word again. She admits, yes, it was suspended. This is what Buzzy said, albeit for unrelated reason. Okay? As defendant assert, it is exceedingly clear that the plaintiff fails to plead actual malice as to this statement. The series explicitly note that, according to plaintiff attorney, plaintiff Twitter account has never been suspended but was instead hacked, resulting imposter I remember reading that imposter account made by third parties to defame his client. There's that. The court agrees that plaintiff therefore fails to, and as a matter of law cannot plead actual malice as to this statement. There's all of that. Granting motion to dismiss, reasoning that comment attribute to representative for plaintiff in the article at issue were contrary to the general conclusion reached in the articles, thereby undermining plaintiff claims of malice. There's all of that. Additionally, the court agrees that the statement will otherwise be substantially true because plaintiff account was suspended. That's it. Yeah, it was suspended by her own admission. In other words, case albeit applied the defamation law of another state, the Northern District of Georgia, rely on similar reasoning to dismiss a claim arising out of CNN's statement that Twitter suspended an individual's account for promoting misinformation, notwithstanding that individual's claim that his account was actually suspended for sharing private information. Wow, there's all of that. Here too, the statement is substantially the same, whatever the reason for the suspension, and thus non-actionable. So they're done with that. Reason, unactionable, non-actionable reason. Statement 18 cannot support defamation claim and will be dismissed with prejudice. There's that. Actual malice. We almost done. Let's see here. We are page 50. Oh my God. 50 up to about 8 pages. Okay. Actual malice. This is gonna be like 2 or 3 pages, 3 videos. Actual malice. Although plaintiff sufficiently alleged publication, all of the claim based on Buzzy's statement from the series, statement 8, 9, 10, 11, 12, 13, 14, 15, and 18 are due to be dismissed for the fact that plaintiff fails to plausibly plead actual malice. Actual malice required that the plaintiff plead and ultimately establish that the defendant act with a knowledge. Okay, it's repeating the same thing again, what it means. Reckless disregard of whether it was false or not. There's the case here. Defendant, there's that, I looked it up earlier, argues on this point require plaintiff to plead allegation that allow the court to reasonably infer that the defendant actually entertained serious doubt as to veracity of the published account or was highly aware that the account was probably false. There's all of that. Malice in this context refer to the truth, not to the plaintiff. Okay? Will improper motive or personal animosity plays no role in determining whether a defendant acted with actual malice. Here, plaintiff falls far short of making a necessary allegation. Her response recite the definition of actual malice and claim that it applies here as alleged in her complaint. However, such legal conclusion need not be credited by the court. Tellingly, none of plaintiff's background allegation plausibly alleged that the defendant had serious doubt about Buzzie's statement or knew that they were false. Further, defendant is correct that based on, there's this case here, plaintiff cannot establish actual malice as to the statement 9, 10, or 18 because the context of those statements were supported by multitude previous reports, specifically based on the article and the record. There's that. Plaintiff alleged harassment of defendant had been widely reported by the time of the series. Wow. Thus, even if defendant were responsible for Buzzie's statement and they were actionable, actual malice is precluded as those statements. Wow. So because other places have already said it, so they cannot blame Buzzie for that. Okay, as described above, each statement is also non-actionable for at least one other reason beyond plaintiff's failure to allege actual malice. Therefore, all the claims based on Buzzie's statement are due to be dismissed with prejudice, as the statement on which the claim are based are non-actionable, and amendment will be futile. Okay, so they're done with that. Plaintiff's original complaint included a claim for defamation by implication, DACT 1, 38-43. Defendant filed a motion to dismiss that complaint, including that claim, DACT 15. Subsequently, plaintiff amended her complaint and replaced the claim with one for injurious falsehood, DACT 31, 55-72. Now the operative complaint revives this claim, DAC 74, 74-82. Notably, it is based on precisely the same statements as the defamation claims and fails to reference any additional statements. Defamation by implication is deemed to occur where there are juxtaposition of a series of facts so as to imply a defamatory connection between them, or where a defamation implication is created by omitting facts. Okay. Importantly, such claims are analyzed under the same actual malice, negligence framework as traditional defamation claims. There's another case here. Furthermore, all of the protection of defamation law that are afforded to the media and private defendants are extended to the tort of defamation by implication. There's all of that. Under Florida law, defamation by implication applies in circumstances where literally true statements are conveyed in such a way as to create a false impression. The case of action, in other words, arises not from what it stated, but from what it implies. When a defendant juxtaposes a series of facts so as to imply a defamatory connection between them, creates defamatory implication by omitting facts. There's this case here. Defamation by implication is thus premised not on direct statement but on false suggestion, impression, and implication arises from otherwise truthful statement. Plaintiff alleged that based on the same statement alleged to be defamatory in court, one defendant is liable for defamation by implication because of how she crafted her false narrative to damage plaintiff. Oh my lord. She argues that defendant silenced the truth by impugning and damaging her character because plaintiff knew the truth of defendant past. Defendant argues for dismissal of court too in full because the statements supporting the claim are non-actionable and protection of defamation law extend to claim for defamation by implication. The court agrees first, plaintiff fails to adequately state a claim for defamation by implication for a simple reason. She fails to identify the literally true facts that will serve as the basis for such a claim. There's this case here. In fact, plaintiff consistently alleges that all the statements based upon which she alleges defamation were false, DAC 72-59. Thus, her complaint logically precludes a defamation by implication claims as she fails to specify the true facts of defendant manipulated to create a defamatory implication. And there's this case here. In order In other words, okay, there it is here. In other words, she failed to specify her defendant has either juxtaposed facts in order to imply a defamatory connection between them or omitted facts in a way that create a defamatory implication. Additionally, the bulk of the complaint and plaintiff briefing focused on the defendant's allegedly false statement. This makes sense because defamation count 1 generally involves untruths, but defamation by implication is, by definition, the manipulation of true facts to create a defamatory effect. There's this here. Florida does not recognize the tort of defamation by implication as a concept by which literally true statement can be defamatory where they create a false impression. With this background in mind, the court can largely put aside plaintiff's many allegations regarding defendant's false statement and why they were false and analyzing this count, where plaintiff does begin to suggest that the defendant has manipulated true facts. Her allegations are insufficient, vague. It is not just the word defendant used, but also how she crafted her false narrative that causes damage. This is something I'm always having on Twitter, that Megan is lying, she did this, she does that. But there it is in court here. The judge is saying here, where did she use true things to manipulate it? Where? Okay, she didn't, the half-sister didn't prove that. So they better stop this thing. Okay, not accomplished by direct statement about plaintiff alone, but also in defendant juxtaposing of lie and fact and surgically precise omission of truth. Okay, so she didn't prove what was the fact, the original truth, and what Megan was said, and that way the judge could compare them and say, okay, this is the fact here, and this is what Megan said. Where was certain part was deleted, and to make you see something completely different. So the judge didn't see that. Okay. But also the defendant juxtaposition of lie and fact and surgically precise omission of truth that, like the spider and the fly, weaves defendant's false narrative and injures plaintiff, encapsulating the unsuspected listener in the gossamer web of fiction spun by defendant. One can look at any one of the above statements from either of the interview and the series and see how those statements damage and defame plaintiff's character by the juxtaposition of defendant's lies with facts to imply plaintiff is a liar, untruthful, fame seeker, racist, and only out to hurt plaintiff to make an unearned and unworthy name for herself. Oh my goodness. These general allegations fail to put defendant on notice of the specific facts she's supposedly manipulated in her effort to weave a tapestry of defamation. Yeah, she didn't show. Okay, generally allegation fail to put defendant on notice specific fact. Okay, there's this case here. Granting in part a motion to dismiss a defamation by implication claim because the complaint made only general conclusory allegations as to the defamatory nature of a lengthy exhibit because plaintiff fails to identify the true facts defendant has manipulated to defame her by implication. Count 2 will be dismissed. It's almost the same thing we'd be asking those people online. Okay, if she's lying, what did she lie about? They can never prove it. Okay, finally, almost there. Finally, a second but no less important reason that count 2 fails is that the court has already found that each of the statements on which the defamation claims were based are non-actionable. As the protection of defamation law extends to defamation by implication claims, this will necessarily doom these claims as well. There's this here. Leave to amend generally. District courts should freely give leave to amend when justice so required. There's that here. Whether justice so requires resides within the court's discretion. There's that here. Okay, the court consider 5 factors in deciding whether to provide an opportunity to amend. Undue delay, okay, where you could the court is explaining here how you could amend certain documents, okay, to give you as much chances as possible, but not to manipulate it in a way. Okay, the court considered 5 factors in deciding whether to provide an opportunity to amend. 1, undue delay. 2, bad faith or dilatory motive. Okay, to delay. You see, there's someone right now who's doing that. Repeated failure to cure deficiencies by amendment. 4, undue prejudice to the opposing party by virtue of allowance of the amendment. And 5, and futility, Blackburn. There's all of that. Okay, here, dismissal of both claims with prejudice is warranted. Wow. So she amended too much. I'm not even a lawyer. We saw that coming. Okay, plaintiff has been giving several... Thank you. Go back to my last video regarding this. Well, there's gonna be... I'm gonna cut this into several parts. But the last time, like last year, that's what I'm talking about. The last year, when I was reading it, the court documents, and I was like, the judge is giving her as many chances as possible. So when she come to the conclusion, they don't say they didn't give her chances. So here that she explained it here. Here, dismissal for both claims with prejudice is warranted. Plaintiff has been giving several opportunities to amend along with guidance. Wow. Along with guidance and a reminder to be mindful of rule. Okay, let's see what is this rule here. Let's look it up. Okay, there's let me leave this. Oops. I closed it. You may not get the link that I was saying. I closed it by accident. Maybe I could look okay, so there's here. What is that? Rule 11. What is that? Let's look it up. And short, Rule 11 set forth certain requirements to create a binding agreement between parties to a dispute. So she reminded them, oh my God, the court reminded her of this rule. In other words, try to talk to your sister. That's what I see here. Try to talk to your sister and settle this thing. The agreement must be in writing or made in open court on the record. The agreement must be signed by all parties involved if made outside of court. I think that's what the court was trying to do, the judge. She gave her as many help, I would not say help, guidance maybe. Okay, and do this rule. Go talk to your sister and settle this out and then bring it to court. Both of you have to sign it so the court could recognize it. So let's see what she said about that. This is very important. Okay, here dismissal of both claims with prejudice is warranted. Plaintiff has been giving several opportunities to amend along with guidance and reminder to be mindful of this rule. Nevertheless, plaintiff's amendments were sparse, though she added a number of deficient claims based on a new publication, often contradictory or unsupported by authority whatsoever, and largely failed to cure deficiencies identified in the court's previous order. As to the interview claims, it's like she was trying to do a brand new kind of claims, new kind of law thing here. Oh my Lord. See Doc 70 at 2025. There's all of that. I think this is very important. Page 56. Moreover, as to count 2, amendment will be futile, both because plaintiff largely fails to even try and indicate which true statements form the basis of her claim, and because all of the protections of defamation law that are afforded to the media and private defendants are extended to the tort of defamation by implication. There's this case here, or law. Having found that plaintiff defamation claims in count 1 are based on non-actionable statements, there is no reason to believe amendment of count 2 will lead to a viable claim either. So she changed some stuff and the court is dismissing everything. Therefore, Any further amendment will be fatal. Of the nearly 20 alleged defamation statement plaintiff has put forward and briefed, not even one survive rules. What is this rule now? Let me open. I'm pissed at myself. I'm upset because I closed the other thing by accident. What is that? Rule 12b6 permitted a motion to dismiss for failure of the complaint to state a claim on which relief can be granted is substantially the same as the old demurrer for failure of a pleading to state a cause of action. Okay. Instead, all of the statement plaintiff seeks to hold defendant liable for are non-actionable under Florida law and the First Amendment. There is no reason to think that another amendment complaint will be different. Conclusion. This is the last page. Conclusion. For the foregoing reason, the court grants the motion to dismiss in full. So now it's completely dismissed. Plaintiff's claim will be dismissed with prejudice as she fails to identify any statement that could support a claim for defamation or defamation by implication by this point. Her third try, I told you the court was giving her chances. Her third try at amending her complaint and either the book Finding Freedom, the Netflix series Harry and Meghan, or defendant in her husband's hour-long televised CBS interview. As such, the third amended complaint will be dismissed with prejudice. Accordingly, it is ordered: 1. Defendant's motion to dismiss for failure to state a claim is granted. Plaintiff defamation claim count 1 are dismissed with prejudice. Defamation by implication claim count 2 are also dismissed. So Meghan 1. 4. The clerk is directed to enter judgment in favor of defendant Meghan Markle, also known as Meghan, the Duchess of Sussex, terminate any pending motion and close this case. Done and ordered in Tampa, Florida, 12/2024. Meghan 1. This part here, this is very important. Her dismissal, they give her chances. Oh my goodness. I'm gonna stop now. I did say I was gonna go over it. That will be another video. I'll put this in another video, but I don't think I'm gonna record any more tonight. Right now it's 2:45. Let me start editing some, and then I'm gonna put some stuff on my community board, what I just read, and share with you. So that's it for now. Oh, let's at least a prayer. Let's do a prayer. Prayer for guidance and thank you. And thank you, just like that. Thank you, Lord. Let's see what we have. Also, thank you, Lord, for keeping me safe. You protect me from those things that seem to haunt others. You help me make better choices and provide me with advisors to help me with life difficult decisions. You speak to me in so many ways so that I always know you are here. Okay, so that's it. Please take a moment to subscribe, like, and share. If you want to support this channel, there's a PayPal link and a Cash App link in the description. You could donate. Those who have donated, thank you. All right, so that's it. I'm not gonna record anymore, and I just need to get this going. And this tweet, I'll go over it on my next recording, probably tomorrow. Thank you for watching.
It is a great privilege to be with all of you today.
We ask for forgiveness and please come back.
As you saw me find the love and happiness that I'd hoped for all my life.
You are all in this together, and if I may speak personally, we are all in this together, because asking for help was one of the best decisions that I ever made. You will be continually amazed how life changes for the better.